Hello and welcome back to the Jurisprudence Podcast with me, Alex.
And me, Charlotte.
And this episode, we're going to talk about the Security Council. So, I think the general gist of this episode, this is an episode that I did, by the way, if international law isn't a clue already.
Yeah.
But this was an episode that was sort of sparked by a bit of debate surrounding a very specific Security Council resolution. And so I thought it would be quite useful to essentially talk about what the Security Council is, how the Security Council works, and then start talking about resolutions within the Security Council. Because there's a sort of general perception for anybody who knows about the UN and the Security Council that when it comes to General Assembly resolutions, they are non-binding resolutions, and then when it comes to the Security Council, they are binding resolutions. And I wanted to just clear up a little bit of the international law on this matter, because essentially not every single Security Council resolution is binding. There are some that are not binding onto parties, and we're going to really focus on the debate around Security Council Resolution 2728, which concerned a 1-month ceasefire in the current Israeli Hamas Gaza war that took place all the way back in March, and there was sort of back and forth about whether or not it was binding or not, and there was some legal interpretation of it. And really, I want to finish by thinking about why it's important that we identify binding resolutions as soon as possible, especially when it comes to like conflict situations like this, and when it comes to Security Council resolutions which are potentially not obviously binding at the outset, or where there are states that get involved and say, actually, no, this isn't a binding resolution, and then why that causes a lot of problems. So that's basically the gist of it.
Yeah, sounds good. So your methodology there is a sort of like a funnel shape. So we're going to talk about the Security Council more broadly and its functions and what it is, and then talk about the kinds of resolutions that it passes down and what this means in terms of binding or non-binding. And I think this is going to be really interesting because from talking to you, it seems to me fairly straightforward in identifying whether a resolution is binding or not. But
yes.
The extent to which this is contentious means that ultimately when resolutions like this come out, they're not really that effective.
Well, yeah, I mean, the sort of spoiler alert for Resolution 2728 is it actually changed nothing within the sort of current Gaza war. Sadly, but it would probably it's questionable whether or not international law has much effect in terms of Middle Eastern politics anyway, generally speaking, given the sort of history. If you want to talk about the history of the sort of Israeli-Palestinian conflict, or you want to talk about the history of broader conflicts in the Middle East, and I don't say that as somebody who is focusing specifically on the Middle East. There's the real question of whether or not international law has a good enough effect more generally. So yeah, it was never really gonna work, and it seems to be the case that whenever we're focusing on the Israeli-Palestinian conflict, international law seems to, for some reason, become more and more complicated, which is quite interesting. Why that happens?
Do you think that it's part and parcel the conversations that happen around it, considering the fact that this is a very heated conflict? There's a lot of back and forth in scholarship as well as politically, geopolitically, which causes people to sort of look for difficulties in international law and make it more complicated than it needs to be, maybe.
Yeah, fundamentally, this is you could probably highlight this as just an example of lawfare, the use of law as a method of warfare. On both sides. This is not like a one size fits all kind of approach where one side is utilizing international law as a method of conducting warfare, or as a method of sort of convoluting the whole situation. Both sides do it. They do it in different ways. It's essentially something that they have given that it's. I mean, this happens in most conflicts, probably in all conflicts. I'm not sure exactly. I'd have to think about why this happens. Seems to happen a lot more in this specific conflict. Maybe because it's a very long, drawn out, protracted conflict. So they've had a good enough amount of time to be able to weaponize international law in a meaningful way. I don't know, but fundamentally, then, in talking about this, then let's begin by just focusing on what the United Nations is, what the Security Council is, how it works, and then start to just break it down bit by bit.
Sounds good.
Okay, so the Security Council is one of the 6 principal organs of the United Nations. The United Nations Charter is passed in the 1940s. It creates and it establishes this new international organization. This new international organization has a number of different organs. These organs include the General Assembly, the Security Council, obviously, the Economic and Social Council, the Secretariat, and also things like the International Court of Justice. Now, the Security Council is very interesting in the sense that it is a much smaller institution than the General Assembly. The General Assembly is made up of just all of the member states of the United Nations. I believe there's 197 at the time of recording. I think the last one was South Sudan in a few years ago, about 10 years ago, actually. Security Council is much smaller. It has 15 members at any one point, okay? And those 15 members are divided into 2 groups. You have the permanent members of the Security Council, of which there are 5, and then you have non-permanent members of the Security Council, of which there are obviously 10. Now, the permanent members of the Security Council are China, France, the Russian Federation, the United Kingdom, and the United States. Now, the reason why these are the permanent members of the Security Council all dates back to when the UN was established, and because it was established and essentially it was being made or being negotiated during the end of the Second World War, the 1943, 44, 45, and these were some of the firstly they were the Allied powers mostly, so France, Russia, US, and the UK, and obviously these were the dominant superpowers at the time as well. When it comes to the 10 non-permanent members, they are elected for 2-year terms, and they are elected by the General Assembly. So at any one time, you'll have countries from all around the world being part of the Security Council and being involved in Security Council resolutions. They are allocated on the basis of regions, so you have 3 seats for the Africa group, 2 seats for the Asia Pacific group, 2 seats for the Latin America group, 2 seats for the Western European group, and then 1 seat for Eastern Europe as well. And so they will sort of just consistently be filtered in and out, okay? I guess the first big point that you wanted to ask is the difference between the General Assembly and the Security Council.
Well, yeah, you sort of answered preemptively what I was going to ask.
Yeah, what is the difference?
Well, yeah, I mean, the clear and obvious difference is the membership of each, but I think the second question to that is the different functions.
Yeah, the function of the General Assembly is much broader, so they do a lot of agenda setting with the passing of their resolutions. They also do a lot of funding, and they sort of allocate funding. The reason why they allocate funding is because the General Assembly is made up of all the states, is the states that fund the United Nations, and so they have a say in the ways in which the allocation of funding takes place. It's a bit like how in a sort of domestic setting, in a domestic legislature, like for example in the US Congress, it is the House of Representatives that controls the budget, basically, that has the power of the purse. And that's because the House of Representatives in the US was historically the only one that was elected, and the general principle is that, well, if we're going to be in control of the taxpayer revenue, we should be an elected body, a bit like the House of Commons in the UK.
Yeah,
as well.
I was just going to say about the government in power holding the treasury and all that. So it's a similar kind of deal.
Yeah, exactly. So that's how it works with the General Assembly. The functions of the Security Council are specifically about the maintenance of peace and security, hence the name, essentially. They will investigate disputes and situations when it comes to international conflicts or friction in certain areas. They will recommend adjustments or settlements. They can establish peacekeeping operations when it comes to armed conflict areas. They can impose sanctions on a number of states who violate international law, so economic sanctions, embargoes, travel bans, all these different kinds of things. Think about the kinds of sanctions that were imposed through the UN on the Russian Federation in 2022 when we see the invasion of Ukraine. They can also authorize the use of force. This is one of the major important aspects of the Security Council is their ability to be able to sanction a lawful use of force. There are a few ways in the Charter that you can essentially use force in an armed conflict setting. A Security Council resolution is one such example of that. You're going to say something?
Yes, I was going to say that really kind of harks back to its original purpose in setting up the UN after the Second World War, to kind of ensure that we don't do that again.
Yes.
So judging when conflict is necessary, when conflict is legitimate, et cetera, preventing or attempting to prevent crimes of aggression and that sort of thing.
Yeah, it's a very important balancing that the use of force, the law on the use of force, as well as the use in bello, the laws of war, has to do, because you sort of have to balance this sort of utopian desire to
never have war.
Yeah, to never have a war, but you can't really impose that on states, because essentially you have to balance obligations that states ought to follow, but also make them realistic and followable, if that makes sense.
Yeah.
Which is what IHL does. IHL balances the ability for a state to conduct warfare with the ability for people to be protected and to minimize the sort of damage and casualties and the sort of pain of warfare as much as possible. If you made it so, for example, in IHL, it was unlawful for a single civilian to die in a conflict, then that would be great. It would be a lovely world in which that could happen,
but it would be impossible.
Yeah, you're setting the standard so high that states are just not going to follow it. Similarly here, like if you set the standard that warfare is illegal in any circumstance, then you've set the standard so high that states aren't going to follow that particular thing. So it allows for the use of force in limited situations, i.e. Security Council resolutions.
Also, if you conduct it in that kind of way, then a lower standard, which is easier to follow, is less likely to engage states to go above and beyond.
Yeah.
So if you set the standard so high that it's unable to be achieved, then states will be like, oh, well, I've already broken the law. I may as well just go do it as efficiently and as devastatingly as possible.
Exactly.
Because I'm already in trouble.
Yeah, exactly. Now, in terms of the biggest problem with the Security Council, most people would argue that the fact that there are permanent members of the Security Council, and that these permanent members are the only members of the Security Council that can veto resolutions. Yeah. That's theoretically okay in a world in which you're not then alleging permanent members of breaching international law. So you can think of all of the five members of the Security Council. You can think of different instances in which they have violated international law. The United States invading Iraq, for example. There's the questionability of the United States' use of force in Afghanistan as well. That's a sort of a little bit more tricky, but still, again, a violation potentially of international law. You've got the Russian Federation, obviously violating international law with the illegal invasion of Ukraine. You've got China that violates international law as well in various different circumstances. And so the UK potentially also violating international law with Iraq as well. Don't forget that, yeah. So these are situations in which it becomes difficult for states to be able to shine a mirror on the permanent members because the permanent members have the veto authority. So when it came to resolutions about whether or not the Russian Federation had violated international law or calling for a ceasefire in Ukraine, the Russian Federation would just veto any of those resolutions. And so that basically renders the Security Council useless in that situation. Similar things can happen when it comes to allies. So one of the things that was happening in relation to this Gaza war is that because the US is an ally to Israel, it means that for the longest of times, from sort of October all the way to March, any potential resolution that was calling for a ceasefire would be vetoed by the United States, potentially, I believe, also vetoed by the United Kingdom. And so it rendered the Security Council a very meaningless institution. But I mean, at the same time, though, you can question the meaning of the Security Council even when it passes resolutions. In this case, what we're going to do in this episode.
Yeah.
So,
one question that I would ask is, why would a state that is having like a resolution being passed against it, essentially, like in Russia's situation, why, even though they're a permanent member, they would be allowed to veto it? It's almost like voting for yourself in a
because essentially the Security Council passes resolutions regarding situations, and so it has the ability to just veto anything. It can veto things to do with itself. Like a country can veto a resolution on itself, because a call for a resolution or proposing a resolution is a sort of internal procedural matter that involves, and does deeply involve, actually, the non-permanent members as well. Don't forget, there's 15 members. And so if 14 members of the 15 decide to put to a vote a resolution on the 15th member, if that 15th member is a permanent member, it can veto that resolution. That's essentially how it's set up. It was set up in a way to essentially allow for a sort of a special amount of power and authority for these sort of hegemonic states. Which theoretically isn't necessarily a bad thing in a situation in which these states are trying to uphold and enforce international law, but at the same time, these states don't uphold international law any more than any other states. It sort of harkens back potentially to a sort of global north, global south debate around surrounding the well, we're the people that make, and this is where international law comes from.
We set the standard.
We set the standards. Yeah. We would never violate international law. We enforce it. These states are the ones that aren't going to enforce it, so we need the power to veto and the power to stay as permanent members. But obviously the reality of that is that obviously doesn't happen.
Well, this is the thing. The major criticism being that these permanent members have the ability to veto and etc. But then if you look at the treatment of African states by international legal organs,
you talk about the ICC.
Yes. Then it seems like it's entrenching the sort of hegemonic structure of the globe in such a way that basically enforces these countries to remain in a state of, I don't know, like disarray or not being able to stand up for themselves and that kind of thing.
Yeah, this is obviously a major critique that the ICC has. The fact that the majority of cases, I believe up until recently, almost every single case involved people who were non-white or were from the continent of Africa. And that's not to suggest that those people there wasn't a valid claim to them being prosecuted, because of course they were conducting quite serious violations of international law. However, the idea that the African countries or the African peoples have a monopoly on international crimes is absolutely not the case whatsoever. And we've sort of seen a slight shift in that with the arrest warrants being issued for crimes against humanity in relation to Vladimir Putin in terms of the ICC there. To a lesser extent, you could argue that crimes against humanity and the arrest warrants for people like Netanyahu and Gallant in Israel, even though they're technically not. The question of race and ethnicity there is obviously a weird one, but they are definitely. Israel is definitely a westernized state sitting in the Middle East. So there is a slight shift in that. There are obviously investigations in relation to alleged war crimes in Afghanistan by US soldiers, by US troops. It's just generally the way the ICC is set up. It's set up in a way that essentially that essentially limits its own authority. It limits its own authority in the sense that it requires complementarity. It requires that essentially states who are willing and able to prosecute their own do so.
Yeah.
And so this sort of is something of a get out of jail free clause, because there are circumstances in which people, like in Great Britain, are court-martialed, and there are prosecutions for war crimes trials and stuff. So it's difficult, this sort of disparity. It's also difficult because the US and the Russian Federation and Israel are not members of the Rome Statute.
Yeah.
So they don't really have jurisdiction, only in places where war crimes are committed in regions that are members, like Ukraine, or who allow for jurisdiction, should I say, under Article 12, Ukraine, Palestine, etc., etc.
Yeah.
So it's difficult. But back to the sort of the UN and the Security Council.
A good tangent.
Yeah, exactly. Well, yeah, exactly. In terms of its legal authority, it is representative as having international legal personality. We know this ever since the 1949 advisory opinion regarding reparations for injuries suffered in service of the United Nations. So essentially, this was a question that related to reparations for injuries suffered in the service of the United Nations, but it does ask the question about whether or not this new institution, remember this is 1949, this new institution has legal personality. Okay, does the UN have international legal personality which will allow it to bring claims on the international stage? And the ICJ made it very clear that the UN does indeed have international legal personality. The court concluded that the UN, being an international organization that was established by sovereign states to carry out the various different functions of legal of international law, must possess legal personality in order for it to be able to carry out those functions.
I think am I right in understanding that because they establish a separate legal personality for the UN, that sort of answers the question of why are certain states allowed to veto, et cetera, because it's not looking at those states as states being ruled against. They're looking at them as sort of internal functioning elements of the UN as its own thing. So the UN Security Council is operating. Does that make sense?
I think that makes sense. I mean, firstly, the UN Security Council doesn't rule against anything because it's not a judicial organ. So it will pass a resolution on a situation that is happening in the world, or in relation to a situation, on what ought to happen, or maybe they recommend happening in that situation. It was made very clear specifically, in fact, the Tadic case at the International Criminal Tribunal for the former Yugoslavia, that, quote, plainly the Security Council is not a judicial organ and is not provided with judicial powers. This was in paragraph 37. Now, the reason why that case is quite important is because essentially it was one of the first trials that was issued in relation to alleged violations in the former Yugoslavia, with the Yugoslav wars, with Bosnia, Serbia, and all these different kinds of sort of breakaway states that came out of it. And because the ICTY was established by the UN Security Council, it was binding onto all parties. Okay, so this is unlike the Rome Statute, in which created the ICC. The ICC was created by a treaty, so you have to be a party to the treaty.
It's an opt-in.
Yeah, it's an opt-in. The Security Council resolutions for the ICTY were not.
Yeah.
So if, for example, a state was harbouring a fugitive that was indicted at the ICTY or the ICTR for Rwanda, they would be obliged to extradite, to bring that person to justice. And the reason why the Tadic trial is very important is because Tadic presented a number of challenges to the legitimacy of the ICTY and made it clear that they were not a legitimate institution. That this was, because don't forget, this was the first trial of an individual for internationally since Nuremberg and Tokyo at the end of the Second World War,
which were contentious in their own right.
Exactly.
Because they were military tribunals. Yes. And there were sort of questions around the legitimacy and jurisdiction of those tribunals, but it was sort of accepted because of the fact that they were trying
Nazi and Japanese war
yeah.
criminals. Yeah, the legitimacy. Well, although in fairness, the Tokyo trial, the legitimacy of that was challenged by one of their own judges. Justice Judge Powell was challenging the legitimacy of that particular tribunal. But let's get on to the sort of the resolutions themselves. So this is the really interesting legal question that really sparked debate in March. I think it was March of 2024 with General Assembly Resolution 2728, which concerned a ceasefire in the Gaza Strip. So, for the longest of time, we've been seeing Security Council resolutions getting vetoed by the United States, and we thought that it would be the same again with 2728, but the United States, instead of vetoing the resolution, they abstained from the vote. So they didn't vote for it, but they didn't vote against it, so it passed. And then afterwards, they came out and said that the ceasefire resolution was non-binding. And the US State Department noted that the US abstention did not indicate a change in US policy, but they also noted that it was a non-binding resolution. This becomes very important, okay, because the question then becomes, well, whether or not the UN Security Council resolution was binding or not. I'm going to give you a spoiler. It was binding. I think most people would argue that it was definitely a binding resolution, and that it's important that we highlight that, because what happens afterwards is that the US say it's not binding. Then this gives essentially carte blanche for states who are involved in this particular situation, i.e. Israel and Hamas, to also say it wasn't binding either.
Yeah.
And to carry on without any kind of challenge, because it essentially gives them scope to avoid being accused of breaching international law by not following the General Assembly resolution. Sorry, the Security Council resolution.
Essentially, hold up, the US said that it's not binding. The US also being a permanent member, so arguably having quite a significant voice on it.
Well, at least they think so, yeah.
Yeah, well, yeah. I'd like to say that I think that's very tricky and very... it seems to be politically underhanded to abstain from the vote and then come out afterwards and sort of throw a spanner in the works to look like, we're going ahead with allowing sort of ceasefire negotiations.
Well, yeah, I think that generally speaking, it feels like, while not explicit, I'm not sure if it is explicitly stated, it feels like the US position on this conflict is that it is diplomacy that is going to try and bring about a resolution. And essentially, we mustn't forget that ever since October the 7th, ever since this war actually began, the US, along with Qatar and Egypt and Saudi Arabia and Israel and representatives of Hamas, have been negotiating various different ceasefire rounds of ceasefire negotiations in places like Doha, for example, for nearly a year now. And there are various problems with all of these different things that have led to no lasting ceasefire in this conflict. It seems to be the case that neither side really wants a ceasefire. It probably benefits both sides, both parties, to maintain conflict. I think most people would argue that it benefits Netanyahu to carry on this war because his popularity is just taken a nosedive, exactly.
Yeah.
Especially since the judicial reforms that we see that took place prior, that led to some of the largest protests in not just Israeli history but human history, and it doesn't benefit Hamas either to see a ceasefire to this resolution, as we've seen from some leaked conversations with leaders of Hamas, basically suggesting that they like the idea of keeping this conflict going on as long as possible. Both sides, it's lawfare. Sorry.
Yeah. Am I mistaken in thinking that there was at least a short ceasefire during this recent...
There was I think it was in November. There was a ceasefire negotiated in November where they would give back, I believe, a number of hostages each week or each day or something, and in return for like I said, a ceasefire in the conflict. Both sides accused the other side of breaching that ceasefire. Of course, it's not actually clear who was the one who breached that ceasefire originally, but since then there I believe there has been a humanitarian pause very recently in terms of getting polio vaccines into the Gaza Strip because of the first outbreak of polio that we saw recently. So that was a sort of humanitarian pause, I believe, that took place as well. But yeah, continuing, Israel still maintains a presence in the Gaza Strip, and I think they want to maintain a presence in the Gaza Strip for quite a while to come. I actually have no idea what this conflict's going to lead to. Anyway, let's get back to resolutions.
I don't think they know either.
No, I don't think they know either. No one knows. No one really has an idea. So, the first question that I need to make it very clear is that the question of whether or not all Security Council resolutions are binding is an easy one to determine. Okay, I'm gonna read from a quote from Sthoeger from an EGIL blog that basically says, quote, "The view that the Security Council resolutions are binding has no basis in law. Indeed, had all Council resolutions been binding under international law, the ICJ would not have set out to determine whether Council resolutions invoked before it were binding, and if so, to what extent." Essentially, this is referring to a number of ICJ decisions, but mainly the Namibia advisory opinion, which does speak at great length about the binding authority of various different Security Council resolutions. Now, there's the question of whether or not it is Chapter 7 of the United Nations Charter that gives Security Council resolutions their binding authority. And Sthoeger also makes the point that, in fact, even resolutions under Chapter 7 aren't necessarily binding, and he cites Article 39 of the UN Charter, which is the beginning of Chapter 7, to make that determination. Because Article 39 says that the Security Council shall determine the existence of a threat to peace or breach of the peace or act of aggression, and shall make recommendations or decide what measures to be taken in accordance with Articles 41 or 42. So this suggests that maybe not even every single Chapter 7 resolution is binding either, given that making recommendations doesn't imply creating binding obligations.
Yeah, and putting both of those next to each other as well, saying shall make recommendations or decide what to do.
Mm-hmm. Yes.
Decide what measures shall be taken. They kind of juxtapose each other. Mm-hmm. One is a little bit less certain than the other.
Mm-hmm. Yeah, absolutely. There is also the fact that the Security Council can adopt decisions outside of the specific remit of Chapter 7, and you can cite Article 25 of the UN Charter in that regard, where it says that the members of the UN, the United Nations, agree to accept and carry out decisions of the Security Council in accordance with the present Charter. So you could make a decision on the basis of Article 25. The Namibia advisory opinion concludes as well that this Article 25 provision actually gives the Security Council the specific power to pass resolutions in accordance with Article 25. So it was a sort of matter of legal debate about whether or not Article 25 creates and empowers the Security Council to make its decisions in and of itself within Article 25, or whether or not it has the ability to just enforce decisions that were made under Chapter 7, if that makes sense. Yes. So a Chapter 7 decision is made, and then Article 25 is a sort of the enforcement provision that allows for those provisions to actually be enforced, to be put into place. But paragraph 113 of the Namibia advisory opinion says, quote, "It has been contended that Article 25 applies only to enforcement measures adopted under Chapter 7 of the Charter. It is not possible to find in the Charter any support of this view." And I could read on further, but I'm not going to.
Yeah.
So those are sort of the different sort of structural and charter-based implications to a resolution within the Security Council. Now, probably the most important part of determining where there is sort of a bit of a legal disparity, or where it is debated whether or not a resolution is binding or not, is the use of operative language in a resolution. So again, quoting the Namibia advisory opinion, it says, quote, "The language of a resolution of the Security Council should be carefully analysed before a conclusion can be made as to its binding effect." So the question here is, the language of the resolution can give weight to the binding authority of said resolution. Anything to add?
Well, I was going to ask, you mentioned the structure of the different articles and chapters under which resolutions can be made, and pointed out that it's clear that the binding nature of it doesn't come from what it is put under. So it's not the fact that it is a Chapter 7 resolution, for example.
I mean, it could be. It absolutely could be. That there's a sort of binding authority of the resolutions under Chapter 7.
That was going to be my question, in that depending on what part of it it's attached to, does that make it more persuasive? Does it err more on the side of being binding, more likely to be, and then the language is the conclusive determiner of that?
I think so. Yeah, I think generally speaking, when we talk about the Security Council, the sort of common consensus is, apologies, the common consensus is that a resolution that is done under the resolution that is done under Chapter 7 is binding, and then when we think about the sort of language that the resolution essentially is operative of, we have to think of the various different words that might give it binding effect and might give it binding authority. So the general consensus is that Chapter 7 resolutions are generally binding, and then the use of operative language gives us further indication of that. So words like demands, requires, requests, authorizes are all kinds of language, the kind of language that can really indicate the binding authority of a resolution. And if we want to just take us back to to the resolution that we've been focusing on, 2728, the ceasefire resolution, it says, paragraph 1, quote, demands an immediate ceasefire for the month of Ramadan, respecting all the parties, leading to a lasting, sustainable ceasefire, and also demands the immediate and unconditional release of all hostages, as well as ensuring humanitarian access to address their medical and humanitarian needs, and further demands that the parties comply with their obligations under international law in relation to all persons they detain.
And it's not just the fact that they use demands 3 times, but also the other language around that. So an immediate ceasefire.
Yeah.
It's not just that parties should undertake to take steps to put a ceasefire into place.
Yes.
Also immediate and unconditional, ensuring humanitarian access. All of these sort of very pressing, obliging phrases and basically enforcing language.
Yeah, it's kind of enforcing language. It's quite it is quite instructive as to what needs to be done, and that's not ambiguous either. There's no ambiguity there with paragraph 1. It demands an immediate ceasefire for the month of Ramadan, and it, with respecting all parties, leading to a lasting, sustainable ceasefire. So a month-long ceasefire with the general aim that it won't actually be a month ceasefire. It will be a permanent ceasefire, but obviously it's more difficult to negotiate a permanent ceasefire than it is to negotiate a month-long ceasefire or a week ceasefire or anything like that.
Yeah.
The sense of permanence is quite a strong thing to try and negotiate at the outset, essentially. Especially when you've got probably the biggest problem in relation to getting a ceasefire, which is the hostages. The fact that there are still over 100 people in the Gaza Strip that have been taken hostage by Hamas, some of which were executed just last week, in fact. So this is obviously an additional problem that needs to be resolved.
So putting in place a month-long ceasefire is sort of giving breathing space and scope for further negotiations.
Yeah, it's if you're negotiating a permanent ceasefire, you're probably less likely to get that over the line than a month-long ceasefire. And with a month-long ceasefire, you can get the hostages back, you can get humanitarian access to people who are affected in the Gaza Strip, and then the aim here is not really to have just a month ceasefire, but to have just time to negotiate further ceasefire arrangements.
Well, the idea is that a month is better than nothing.
Yeah, exactly.
And it also harks back to your other episode a couple of weeks ago, where we talked about ensuring unanimity within the court.
Yes.
So this idea of being sort of broad brush and a bit vague in order to have a consensus. The idea here is that we want a consensus between both parties, and it's a lot easier to get them to agree to something that's a bit lesser than what we would actually want, which is a lasting peace.
Yeah, exactly. It's pragmatic.
Yeah.
It's pragmatism, fundamentally. I think finally as well, if we're thinking about binding authority, there's also the question of statements and debates and the intention of the party. So intentions of the states because states obviously have opinions in the Security Council, and they write things down and they make statements and they say things. So what did the members of the Security Council believe they were doing when they were passing Resolution 2728? Yeah. Did they think that they were passing a non-binding resolution, or were they passing this resolution with the view that it had binding authority? According to Greenwood, from the Modern Law Review, all the way back in 1992, he says, quote, "It is impossible to properly understand the text of any Security Council resolution without reference to the debates which preceded it." So you can't just look at it in a vacuum and go, well, what does it say? Oh, whether it's binding or not from that basis. You have to think about the debates that created it, because essentially, as stated by the ICJ in the Kosovo case, a Security Council resolution isn't a treaty. It has stuff that is voted on with its own procedural elements that take place under the remit of the UN Charter within the Security Council itself. So
it's almost like a living example of law. So it takes on its own life from the input of the states that debate it and pass it through.
Exactly, and that causes deliberation. That causes problems at times, because there were ceasefire negotiations going on in the Security Council all the way back in and in the General Assembly as well, all the way back in October and November, where states were trying to add in bits or take bits out, and that causes the resolution to fail, or that causes the resolution to be weakened in one way or another. There was a very good example of, I believe it was Canada, that wanted to have a General Assembly resolution or a Security Council resolution, including, they wanted it to include the immediate release of hostages in the current Gaza war, and that caused some states to say, well, no, we don't want that, because obviously states have their own political agendas and their political affiliations. Yeah. So the Kosovo case says, quote, "The interpretation of Security Council resolutions may require the court to analyse statements by representatives of members of the Security Council made at the time of their adoption, other resolutions of the Security Council on the same issue, as well as subsequent practice of relevant UN organs and states affected by those given resolutions." So it's quite a holistic view that the ICJ is suggesting here. If this is the opinion of the ICJ, essentially, if the ICJ is tasked with determining the analysis or the interpretation of a Security Council resolution, they're not just going to take a very textual look at what the words of the resolution say themselves. Yeah. Because resolutions in the Security Council are often very very short. This one was only a couple of paragraphs, I believe. It wasn't a very long resolution. And so it requires you to understand, right, what were the states thinking? What were the statements that were made by the states? What about the practice afterwards? What about similar resolutions on similar issues? All these things obviously contribute to having a better understanding of the binding authority or the interpretation of a particular resolution.
So, in a sense, this is what gives scope to the argument that the US coming out and saying that it's a non-binding resolution, because if you're looking at the sort of statements or intentions of the states that took part in passing that resolution, then that has an effect on whether it's binding or not.
Yeah, potentially.
However, I would say that they don't really get that because they abstained from the vote. So they didn't take part in passing the resolution. So
theoretically, but given the fact that the US is just a member of the Security Council,
yeah,
gives their opinion a certain amount of weight and voice.
regardless
so
of
regardless if they got involved or not, because even if they may have abstained from the vote, they were still heavily involved. I believe they were still involved with negotiating this resolution, or debating this resolution, or talking about this resolution, or talking about prior resolutions on ceasefires that they themselves proposed, as well as other resolutions. Don't forget, the US have also proposed resolutions for ceasefires within this particular context, but with different wording, slightly different obligations, and all these different kinds of things. But in terms of this specific resolution, 2728, it should be noted that it was firmly the case that 9 of the 15 total members of the Security Council were firmly of the view that Resolution 2728 was a binding resolution.
Right.
So not only was it a resolution that was done and passed within the sort of spirit of Article 25, not only was it a resolution that used operative language in its determination, it used the word demands, for example, 3 times in paragraph 1.
Yeah.
Not only is it a resolution that most people were negotiating, that you could see from the negotiations was seen to be a binding resolution, but it was also the case that the majority of, nearly the supermajority, in fact, of the Security Council at the time were passing this resolution with the view that it was a binding resolution. And I think all of those things together presents a pretty indestructible argument that Resolution 2728 was a binding Security Council resolution. And so, therefore, the US was incorrect in that determination, that as the US is often incorrect. But the problem here is, of course, that it then led to people like Benny Gantz, who was a member of the Israeli War Cabinet, saying that the resolution has no operational significance. You have the question of whether or not the resolution, even if it was accepted by everyone as being binding, would make any difference at all, because both sides of the conflict, because it was a resolution on a ceasefire, because it was a resolution on maintaining peace among two parties, it required obligations on both parties.
Yeah.
So it didn't just require the obligations of one state to do a thing or to not do a thing. It required both parties to do things in order to maintain the upholding of this resolution.
Not only that it passed obligations to two parties, but the fact that it's quite a tenuous dynamic that it was suggesting in terms of giving back hostages, ensuring that humanitarian aid could take place. So it was like enforcing an ongoing kind of relationship between the two parties, not just that they had to do like a trade, and that was that.
Yeah, and it should be noted that essentially what the Security Council resolution did was basically tell the parties to do what we all believe they have been negotiating to do anyway.
Yeah.
So they've been negotiating for months the return of hostages. Some argue that not well enough, or maybe for ulterior purposes, or maybe for being deliberately obtuse in order to maintain the conflict on both sides. Both sides have accused the other side of doing that.
Yeah.
Both sides have accused the other sides of rejecting ceasefires. Both sides have indeed rejected ceasefires and rejected proposals for ceasefires. But the one thing that we do know is that both sides have continued to be part of negotiations with countries like Qatar and Egypt and Saudi Arabia and the US and the UK, I think, as well. So the result there is essentially that the UN Security Council passed a resolution that definitely had political significance. It was definitely legally binding, but that, as we are recording this in September, didn't achieve anything of any kind of note. I think that in terms of this conflict, we're probably just going to see it like slowly fizzle to the point where there's still ongoing hostilities, people still die, conflict is still happening, but that it is just sort of slowly, the state of affairs will just slowly morph into very much on the ground occupation of this territory, in a similar sense to how it is in the West Bank, which would essentially sort of throw back any peace settlement and any self-determination of Palestinian territory another 20 years.
Yeah.
Because it was 20 years ago that Sharon left the Gaza Strip and took away everything from the Gaza Strip and sort of left it on its own. And now we're going back to boots on the ground.
Yeah.
Even though that's happened at various stages with Operation Protective Edge and other operations in 2008 and 2013, they eventually leave the Gaza Strip afterwards. It seems that the motivations of at least the Likud at the moment is to maintain a permanent IDF presence in the Gaza Strip, potentially for the foreseeable future, because their goal of eliminating Hamas is not a viable goal. It's not a goal that's going to be. It's going to be a situation where we sort of move to a sort of guerrilla system of warfare, where the military aims are just unobtainable, and so that's what's going to probably happen until pressure is imposed to essentially resort in a ceasefire. So yeah, anything you want to
add? Well, I was just going to add to that and say that from my perspective and what you've told me about the history of the relationship between Palestine and Israel is that it sort of had this pendulum swing approach to hostilities, in that it'll fizzle and then the tensions will rise and eventually explode, and we'll see something happen like October the 7th. And then there'll be hot conflict for a while, occupation, and then it'll go back to sort of quietening down again, but the tension still being there.
Yeah.
And I think what you're alluding to is there needs to be more of a hard line stance from external forces to force them to sort of work this tension out in some way. Yeah. And that's what's tried to happen in the past in terms of, working out sort of territorial line drawing and that kind of thing, which hasn't worked, obviously. No. And so there needs to be some kind of other I mean, the time is up now, because essentially the time is up. There needs to negotiate a two-state solution. A one-state solution is never going to happen. It is just, if it does ever happen, it's going to be in 100 years' time. The idea of Palestinian Arabs and Israelis living together harmoniously in a state is just not feasible. It's not, as historian Benny Morris coins it. It is just the sort of conversations that people have in French cafes, and that they can sort of conjure up this utopian world in which there's a one-state solution, but the reality in the Middle East is that that's just never going to happen. It also hasn't got a basis in international law, whereas a two-state solution has got basis in international law with Security Council Resolution 242 all the way back in 1967. So a two-state solution has to happen. The Israeli occupation is illegal. We've noted this from the previous advisory opinion episode that we did. Yeah.
It's unlawful. The West Bank occupation is unlawful. It borders on apartheid in the West Bank. Probably, I would conclude that it was probably apartheid. The ICTY was obviously vague on that determination. It was at least an Article 3 CERD violation. So the West Bank is unlawful. The settlements are unlawful. The current conflict is unachievable of any goals or any aims. Probably diplomacy is the only way of achieving any kind of returning of hostages and anything like that. So at this point, international pressure should be to force a two-state solution, but it doesn't seem like the current Israeli government wants a two-state solution.
Mm-hmm.
It doesn't seem like Israeli society want much of a two-state solution. They're getting pushed further and further right. It doesn't seem like anybody in the West Bank want a two-state solution, or even whether or not Hamas definitely don't want a two-state solution.
No.
So the solution is something that no one wants.
Yeah.
So ultimately, this is probably just going to carry on for another 10 years. Is the beginning and ending of it, and we're going to talk about it on podcast episodes and for ages.
Well,
Good luck for that.
On that cynical note, is there anything else you'd like to add?
I don't think so. No.
Well,
I think we're basically
very good.
I think we're basically done. Yeah.
Everything is terrible, and international law isn't helping it.
Well, it hasn't. International law
Yeah.
has never helped this situation, unfortunately.
Well.
So yeah. I hope everyone's enjoyed this episode. I hope everyone's learned something from this episode on the nature of the Security Council. Look forward to when I do a post about this, I'll talk a little bit more specifically about Resolution 2728 and its binding nature and why it is, in fact, a binding resolution.
Mm-hmm.
I'll do that over the coming days when this comes out. And stay tuned for the next episode in a couple of weeks, which is going to be a you episode.
That'll be a me pick, so probably something to do with terrorism.
Or crime.
Or crime.
Yeah, exactly.
Or I might branch out, who knows.
Yeah,
Stay
exactly.
tuned.
Yeah, exactly. One more announcement is that we have put this on Spotify.
Yes.
So these are all going to be on Spotify as well, and on your other podcast, whatever podcast source you consume your podcasts in.
Your preferred medium.
Exactly. They will be on there as well. Again, Joe, I hope everybody's enjoyed this episode and stay tuned for a new episode in a couple of weeks' time.